Good afternoon, everyone. My name is Arul, and if you're able to hear me and if you're able to see me, give me a thumbs up or give me a yes. If you're able to hear me and you're able to see me, so at least I know technically everything is okay. Okay, good. Yep. So thanks a lot for joining us in our webinar series for Q1. So this is our second webinar. Last week we had a webinar on flexi work arrangement. So today's webinar, it's on Employment Act Amendment, right? Employment Act 1955 Amendment. So this webinar will take roughly about 2 hours. So it is now about 3:05. We should finish it by 5:05 or so. What I'm going to do is I'm going to share with you, there's 3 parts. The first part is going to be on Employment Act. I won't cover everything because there's a lot to cover, but I'm going to cover some of the key components of the changes and giving you some ideas, some methods or some tips how to implement it, some salient points, what to take note of. Then I'll cover a little bit on some other aspects, for example, minimum wage. I'll cover a little bit on definition of wages. And on the last part, or the last part of the webinar, I'm going to cover some HR breakthrough strategies, which I've promised to some of the members. Come and listen, and I'm going to share with you some strategies that you have never heard of. 1 or 2 of them I've shared in the previous webinar. I will repeat those strategies, plus I will share 1 or 2 more in today's webinar. So I hope you will stay until the end to get these strategies. Employment Act, I think you should know it. Probably it's just a recap for some of y'all, but the breakthrough strategies is something that you'll be able to learn, implement, and see new results that you have probably have never seen in the past. So that's what is going to happen today. And so for those of y'all, if you're joining in today, you have seen me, you know us. I would have some of the names that I see in the chat, or those of you who joined today, names are quite common. Thanks a lot for joining us today. My name is Arul, and I was like all of y'all once upon a time, working full-time as an employee, as a HR professional, managing HR affairs in the company, etc. That was in the past. I have left the job. My last employment was in 2018, 2021. 2021. And then I have set up, me and colleagues, we have set up this HR forum. And today we provide consulting, advisory, conferences, webinars like what you see today, seminars. We do a bit of documentation write-ups, HR competitions, and many more things. So for those of you all, if you want to contact me, my number is at the bottom, my email is at the bottom. But I may not be able to respond to all your queries. If you have any questions to ask, please ask in the WhatsApp group, or please ask in the Facebook group that you are in now. Now, before I begin, I would like to, maybe just give me a second. So before I begin, I would like to just share this one slide that I have always, provided, always shared in all my webinars and trainings. So it goes like this. If you think compliance is expensive, try non-compliance. So basically what it says here, compliance, if you follow the law, when we follow what the law says, we follow, don't try to take shortcuts and whatnot. So when we follow the law, it is much more cheaper than when we don't follow the law. Or shall I say, when we try to pandai, don't do this, we don't include meal allowance into ORP, or when we pay commissions or incentives, we don't include, we don't pay the EPF for it, etc. That means we are non-compliant. So when we are non-compliant, if the authorities find out, the penalty will be much more severe. So that's what it says here. Compliance, compliance is cheaper. So if you think compliance is expensive, try non-compliance. So there are companies that have gone, into issues because they choose the non-compliant route. And so, for example, even in our private lives, we decide to go and have a quick nasi lemak somewhere. We don't put our parking coupon. We thought the majlis guy won't come, and we have our meal and we run back to the car. There's a summon, right? If we were compliant, the cost is probably 60 cents. Because we chose not to be compliant, Now we end up paying 20 ringgit, 30 ringgit, whatever rate the town council, imposes. So again, I would just repeat, if you think compliance is expensive, if you think compliance is expensive, try non-compliance. It's much, much more. Now, before I begin the sharing for today, I just want to run through this one slide. Some of you all may have seen this from previous sessions or trainings if you've attended. Now, there are three ways how employment laws come into existence in Malaysia. In other words, when we talk about employment law, our practices today, what we can do, what we can't do, where does this come from? Right? Some of you all may think that, okay, it's from Employment Act. That's true, but not everything comes from Employment Act. So where does it come from? So to understand better, we need to know this. There are three ways how laws, or three channels how laws come into existence. The first is Act of Parliament. So any laws that goes to Parliament, Parliament approves it, that is called an act, right? Akta. For example, Employment Act, which most of you all are very familiar with, or even Sarawak Labour Ordinance, Sabah Labour Ordinance. It has got to go to the Parliament, debated, Parliament approved, then it's enforced. Then we have got Industrial Relations Act, Trade Unions Act, Minimum Retirement Age Act, OSHA Act, right? And all the acts, anything with Akta goes to Parliament, Parliament debates, Dewan Rakyat, Dewan Negara, then it goes to the King, and then the minister will then enforce the date, announce the date for enforcement. So that comes from Parliament. But for example, in Employment Act, can we find everything that we want to know, today's practices? Can we find everything Employment Act? For example, if we were to retrench an employee, we need to pay, if the employee has worked for less than 10 days, less than 2 years, we've got to pay 10 days wages per year of, every year, 10 days, 15 days, 20 days, or overtime. What is the maximum overtime limit? It's 104. Where can we find this 104? Can we find this 104 limitation in Employment Act per se? Answer is no. So there's another third bubble. So you can see first bubble, Acts of Parliament, the next bubble is case law, and the third bubble is regulations, by the minister, for example. So the third bubble is where the minister creates regulations. For example, minimum wage order, employment and termination layoff regulations. So for example, if you're going to terminate somebody, the termination benefit, assuming they're earning below 4, they are manual labor. So for those who are below 4 or manual labor, if you're going to terminate them, we got to pay 10 days, 15 days, 20 days. Where does this come from? From the employment in bracket, termination and layoff benefits regulations 1980. So it comes from that particular document. Now, is this a separate document by itself? No, it is an extended form or extended part from the Employment Act. So that's one example. Or if you look at the bottom on the right-hand side, limitation of overtime regulations. So what is this limitation of overtime regulation? In this particular regulation, it says that the maximum allowed overtime for normal days, not Sunday, not rest day, not public holiday, for normal days, it is 104. So you will not find it in Employment Act per se, but you'll find this in the regulations. The other regulation that most of you all may not be familiar with is the Employment Regulations 1957. For example, in this regulation, it spells out what are the details that you need to have in your employment contract. Your pay slips, should it be in hard copy or soft copy, right? Most of you are using soft copy. Is soft copy permitted, right? So Employment Regulation 1957 tells you, what you need to have. For example, in pay slips, what are the components that you must have in your pay slip? It is provided for in Employment Regulations 1957. Or when a female employee goes on maternity, what must you do? You got to fill up a maternity register, right? There's it's a register that you got to fill up and you keep it. When the labor officer would like to come and inspect, they may ask you, can you show me the maternity register? Then you got to take this particular document out. Where is this stated? In the Employment Regulations 1957. So we got to get familiarized with these regulations. So I would encourage all of y'all, try to purchase this one book, right? This book is about 30 ringgit or so. You can find it in popular bookshop. So it is Employment Act 1957. So the Employment Act, all the regulations that you see here, and many more. It's in this book, right? So for those of you all, if you're attending the masterclass, we'll give this book for free. But if you're not attending masterclass, I would encourage you all to go and get a copy from bookshops. Popular do have them, right? So this is something that every HR practitioner, you must have. Okay, and so these are easy. Act of Parliament, you look at the Employment Act, you look at the orders, regulations, you can read it, you can highlight, you can show your superior. If your boss says, can you show it to me? You can show. But there are also many practices that we do today that we are expected to do, which is not mentioned clearly in Employment Act, not mentioned in Employment Act, not mentioned regulations. So where does it come from? For example, fixed term contract. If you're going to hire an employee on fixed term contract and we hire them on 1 year, we renew another year, renew, what does the law say? Are they permanent employees? Are they employees on fixed term? So from the Han Chiang School case, right? It's a case, one of the famously quoted case when it comes to fixed term contract. What does the Han Chiang School case says? Right? There could be a possibility if an employee is being renewed year after year after year after year, but that task that they do is a permanent task. That means the task will always be there. That could be deemed as permanent contract, right? We learned this from the case of Han Chiang. Or a domestic inquiry. How should we, what is expected from companies when you want to terminate an employee? How do you prove that you're given employee an opportunity, right? Those are domestic inquiry practices. So if you read cases, it's mentioned there what is expected from the company. Or when you want to carry out retrenchment, for example, in the recent case that you all may have read, we have shared this in the forum. If a company wants to retrench an employee, you shouldn't retrench to avoid costs. Is a company in financial distress? Have you tried other options? Have you tried to retrain this employee? Maybe retrain and redeploy them to another site, right? So what should you do? Recently, there was also a case. A female employee was pregnant. What does the court say about retrenching a female employee, right? So all this comes from case laws. Or if a company wants to terminate an employee on medical grounds, the employee is no longer able to work, they are medically incapacitated, whatever. So what do we do with them? What is frustration of contract? So all this we can learn from case laws. So the first bubble, which is Act of Parliament, is easy. The third bubble, orders, regulation, you can read it, highlight, and so on. But case laws, it's a tricky one. Why? Because now you got to read these case laws, digest what the court tells us, understand what the court tells us. So that's why some of y'all, you always, when you read Employment Act, you can't find the answer. You read some of you may not even know about regulations, right? You read the regulation but not find answer. What do we do then? We start calling here, there, etc. Different people start to give different input, different opinion. So it is always advisable for all HR practitioners to read cases, right? When the case goes to industrial court, when it goes to the high court, when it goes to the appeal court or whatever, especially if people talk about this particular case, hey, there's an interesting case. We need to develop the habit of getting a copy of the case award or the judgment, read it, understand. So the next time, if similar scenario happens in your company, you have some idea what to do. And not always running around looking for answers, calling here, calling there, and whatnot. That's not very good in the long run, right? For example, there's another case that was shared. If a company suggests an employee to resign, so the company says, you know what, we don't want you anymore, your performance is bad, it's best you resign. Now, is it wrong for the company to say, suggesting an employee to resign? The court, in the case of Matrix Global, if I'm not mistaken, the Court of Appeal said, suggesting an employee to resign is okay, unless you force them, right? So suggesting an employee to resign, when you don't know what else to do with this employee, the court says it is acceptable, provided you don't pressure them to resign, right? So the next time when you have a difficult employee and you do not know what to do with this employee, you've tried all the options and you still cannot manage them, so having a conversation with them, suggesting them is best they go, the Court of Appeal says is okay, right? So when we know this kind of instances, what we can do, etc., it makes your HR process management easier. So my advice to all of y'all, forget about the past. But starting today, spend some time to read cases. Now, I know there's a lot of cases to read, but follow us in Facebook. And every time when we post a case, whether, I do post quite a bit, we have other members who post, etc. Always make this habit, right? You must have this fear of missing out. FOMO, right? Fear of missing out. You see a case, download it, put it on your desktop, right? When you have some time, open up, read it, right? Print it, highlight, digest, and share these cases with your boss. Boss, you know what? I want to share a very interesting case. This has happened. This is how we educate the bosses, right? We don't just go to the boss to say that, this one, we can't do it, right? That is too late. You should always educate the boss ahead of time. Boss, I want to share with you 2 cases that was shared recently, which I think is important to know, so that when we have similar scenario in the future, at least we know what to watch out for, right? A progressive HR practitioner will do that. A reactive HR practitioner, they won't do anything. When something happens, they go around like headless chicken, what to do, how this, that, etc. They start scrambling around for answers. So I would encourage all of you all, starting today, please follow us closely in Facebook, our Facebook community. Download these cases, participate in the discussion, see what others are saying, digest, put on your thinking cap, build your thought process, right? So that the next time if it happens, you know what to do. Now, I would like to encourage all of you all. I'm sure if you're listening in to me today, you are in our Facebook community. But please get your subordinates. If you're a HOD, get your subordinates to join, this community. Right now, it's no longer 56,000. We are about 69,000. Yeah, slightly outdated slide. But there's a QR code. Get them to sign. Every now and then, there will be new forms, policies, samples, templates being shared in the forum. Download it. For example, the upcoming holiday for Wilayah Persekutuan, the 2 public holidays that falls on 1st of Feb. If you go to the Facebook community, you can download sample policy, a short FAQ, what to do in this scenario, right? What happens if Sunday, for most of you all, Sunday is a rest day, but what happens Sunday is an off day? Because, for those in, a certain shift, or if you're in some different operations, some of your employees, they are off day, rest day. Rest day is not Sunday. Sunday could be off day. So now there's 2 public holiday falls on a Sunday. What do you do? So those scenarios are shared. So get your subordinates to join the Facebook community and ask them, download documents, compare against what you have. If there's something you can improve, go ahead and improve it. Or if there's something you like to share in the Facebook community so that other members can also learn from you, right? So don't waste this. It's a free resource, no charge to it, no cost to it. So make the best use of it. And of course, you have, like today, webinars, and the webinar last week, and the webinar next week. So these are the kind of resources that is available in the forum. Okay, so let me jump into minimum wage, then I'll go into Employment Act. Now, why is it important to talk about minimum wage? Because we hear rumors about the next minimum wage increase is coming soon, or coming along. So what is minimum wage? Minimum wage is governed under the National Wages Consultative Council Act. We call short form is NWCC. So under this act, the government decides what should be the minimum wage. So minimum wage today, it's 1,700, right? It was increased in 2024. Minimum wage only includes basic salary. It doesn't include allowances, incentives, or any other payments. So the gaji pokok has got to be 1,700. No allowances, incentives, or any other payment. Purely basic salary. So we can't say that the basic salary 1,005, allowances 200. When we put together, we champo, it's 1,700. No, the basic salary has got to be 1,700. So that's what the minimum wage order says. And so you can either pay employee on monthly. If you're paying them on monthly, like for example, all of you are probably on monthly salary. If you're from HR, I'm very sure all of you all are on a monthly salary. You probably are paid 2, 3, 4, 5, 6, 7, etc. So for those employees who are paid on monthly salary, the minimum wage is 1,007. For those who are paid on daily, right? 6 days work, you come, I pay you per day. So if the employee is engaged on a 6-day work per week, then per day it is 65.38. If you engage them 4 days per week, that is 98.08 per day, right? If they are on hourly basis, then it is 87.2. Sorry, 8 ringgit 72, 8.72 ringgit, right? 8 ringgit 72 cents for every hour they work if they are paid on hourly, right? Now, of course, some of you all may not know this. If somebody is on a daily rated, now they also enjoy annual leave. They also enjoy MC. They also enjoy public holiday, maternity leave, paternity leave. So, for example, if I'm paid on daily, or I'm working on 6 days work per week, every week I work 6 days, and every day I come to work, what I earn is about 65.38. Now, I could be on MC today. Today is Thursday, is my working day. I'm on MC. You still have to pay me because some idea out there, if they don't come to work, I don't pay, right? Remember this, the mechanism of calculation, how you calculate salary is different, monthly, daily, hourly, but every one of them, whether you're on monthly, daily, hourly, you are entitled for MC. You are entitled for hospitalization leave, public holiday, annual leave, etc. So it does not mean that, as a daily employee, I'm not entitled to annual leave. No, I'm still entitled to annual leave, except that if I don't come to work and I don't apply annual leave, just for fun, I don't come to work, I don't get paid. But I can apply annual leave today, right? Because I'm entitled to minimum 8 days. If I don't come today, I can apply annual leave. You still have to pay me salary for today, or if it's MC, or if it's public holiday. Now, if you read the minimum wage order, you'll also find, the order says that employees, if you look at notes, look at down there, note number 1, you can also pay an employee on piece rated, tonnage, task, trip, commission. But whatever you pay them, the minimum that they must get, or the minimum that you must pay them within normal hours of work has got to be not less than 1,700. So for example, if you see the cement trucks on the road, the cement truck with the big cylinder at the back, the rotating cylinder. So those truck drivers, some companies pay them for every trip or every ton of cement that they deliver. So you can also engage a lorry driver. You tell this lorry driver, every time you deliver a shipment or you deliver and you come back, you make one trip, you deliver and come back, I'll pay you 100 ringgit per trip. In 1 month, during your normal hours of work, I will guarantee you 17 trips. So 17 times 100, it's 1,007. So that is minimum wage, right? So even those people who are on task, trip, commission, they also enjoy OT. So if they deliver the truck after normal hours of work, the OTA applies to them as well. So this is roughly the idea of minimum wage. And now let me touch on the Employment Act. One of the major amendments, one of the key amendments in the Employment Act is the first schedule itself. Some of you all may recall, before this amendment took place, right, only those employees earning, if you look at, earning 2,000 ringgit, for this for Peninsula, those people earning below 2,000 ringgit, and if they are manual labor, those who are supervising manual labor, or those who are, running any mechanically propelled vehicle, this group, they are covered under Employment Act. So for HR practitioners like you, if you're working back then and you are earning more than 2,000 ringgit, you are excluded from Employment Act. So that was in the past. But now, as long as you have an employment contract of service, anyone that that is a contract of service, they are covered under Employment Act. So that means if you hire a CEO or a director of quality, a director of sales, and you give them an employment contract, which is a contract of service, they are covered under Employment Act. So CEO of a bank, right? If you look at Maybank, CIMB, all these banks, they are paid so high, so well. They are employed, if they are given a contract of service, they are covered under Employment Act. So an operator, covered under Employment Act. Foreign operators, covered under Employment Act. Fixed term contract, it is also a contract service, covered under Employment Act. So one of the key changes, everybody is covered under Employment Act. But, this, if you look on the right-hand side, the brown box, those 6 subsections do not apply to certain category of people, right? So everybody's under Employment Act, from the operator to the CEO, right? Everybody's under Employment Act. But these 6 items that you see, right? Rest day pay, pay work done on OT, normal days, OT pay, etc. So these 6 subsections do not apply to certain people. So to best explain, let's look at this diagram. So you can see on the right-hand side, employees engaged in, and this is quite similar to Sabah Sarawak. So for those of you all, if you are listening in from Sabah Sarawak, this is very similar. So for those of you all, if you are listening in from Sabah Sarawak, let me just give me a second. Okay, so if you are listening from Sabah Sarawak, almost similar. So those employees who are doing manual labor. So you can go and read who's a manual labor. Those who do repetitive tasks, those are manual labor. Your operators, your cleaners, those are manual labors. Some of the lorry drivers, technicians, they are manual labors. So those who are doing manual labor, or if they are maintaining any mechanically propelled vehicle, for example, lorry drivers. So if this group, or if the employee is supervising or he's overseeing any other employees who's doing manual labor, right? So they are in this first category. Yeah? Now, Employment Act don't follow position titles. You may call somebody a manager, but if he or she is supervising a manual labor, high chances they will be in this group, right? So remember this, titles is created by us, but for Employment Act, they look at what they do. So those who are manual labor, those who are operating or maintaining any mechanically propelled vehicle, that means any machineries, for example, or vehicle, sorry. And if they are overseeing, they jaga another operator, for example, who's doing manual labor. So for this group of people, it does not matter whether they're earning below 4 or above 4. So all provisions, if they work on public holiday, you got to pay them public holiday pay. If they work on a rest day, you got to pay them rest day pay. If they do overtime, you got to pay them overtime. If you terminate this group, you got to pay termination benefit, right? So this group, those who are manual labor, those who are operating or maintaining any mechanically propelled vehicle, those who are overseeing or supervising any other employees in manual labor, this group, it does not matter what they earn. So if a lorry driver earns 10,000 ringgit, he falls in this category and OT has got to be paid. Or if you have a supervisor, or doesn't matter who, title again, takira. So if you have somebody in your company who is overseeing or supervising another employee who's doing manual labor, so let's say operator, like easy example. So if you have somebody, doesn't matter who is it, supervisor, executive, whatever, even managers could be. Now, if they are supervising a manual labor, they may fall into this category and OT has got to be paid to them, right? You might want to go and study this further. Now, that's one category. The other category is the other employees. So, for example, HR executives, production manager, sales manager, sales exec, HR clerk, finance clerk, quality engineer, let's say, R&D engineer. So this group of people falls in the category of other employees, right? I'm just giving you a way how to understand this. So for this group of people like you are in HR, you fall under the category of other employees. So for people like you, like me, like the engineers and managers and directors, sales managers, sales exec, HR clerk, finance clerk, if they are earning up to 4,000 ringgit, you got to pay them OT. You got to pay them rest day pay. Public holiday. If they work on public holiday, you got to pay them public holiday. If you terminate them, you got to pay them termination benefit. But if this group, they are earning above 4, that means 4,001, 5,000, 6,000, 8,000, and they are under the category of other employees, no OT pay. That means if they work OT, that OT provision doesn't apply to them, right? If you terminate them, you retrench them, you don't need to pay termination benefit. So that is in the red box. So usually when you ask me questions in Facebook or whatever, I always refer to the green box and the red box, right? So I want to just give, just want to test you all. You just let me know whether it's green box. Let me just open up the chat box. So let me know whether this is green box or if this is red box. Okay, just give me a second. Okay, so now I'm going to give you a position and the salary. You tell me whether these people are in the green box or are in the red box. Okay, so now let's say, HR clerk earning HR clerk earning 5,000 ringgit. Green box or red box? Anyone? HR clerk earning 3,000 ring. Sorry, HR clerk earning 5,000 ringgit. Red box or green box? You want to assist me what they reply? Yeah? Red box. You're right. So HR clerk earning 5,000 ringgit, red box. Production engineer earning 2,800 ringgit. Production engineer earning 2,000 ringgit. Green or red? Anyone? Production engineer earning 2008. Green box, you are right. Whoever said green, you are right. Operations director earning 3,800 ringgit. Operations director, green or red? Okay. So just now, production engineer earning below 4, they are green box. Operations director, because they are under other categories, they are earning below 4, green box. Lorry driver earning 12,000 ringgit basic salary. Total salary is earning 12,000 ringgit. Are they in the green box or red box? Lorry driver earning 12,000 ringgit. Green or red? Anyone? Right? You're right. Lorry driver earning 12,000, they are in the green box because they come under the first category of employees who are, manual labor, operating or maintaining any mechanically propelled vehicle. They come from this group. So good, now you know who is in the green box and the red box. So those people in the green box, and listen to this carefully, yeah? Chinese New Year is coming, and or the Federal FT Day is coming. Now, those people in the green box, listen carefully, yeah? If they work on public holiday, you got to pay them public holiday pay. You cannot say, maybe if you come and work, I'll give you replacement leave. For those in the green box, you have to pay them public holiday pay if they work on public holiday. Those in the red box, you can give them replacement leave. If anyone in the green box, if they work on a rest day, you got to pay them rest day pay. Those people in the red box, if they work on their rest day, you can give them a replacement leave, time off, whatever you want to call it. So for those people in the green box, remember this, those people in the green box, the 6 items that I shared just now, you can see it at the bottom, right? Rest day pay, pay for work done on a public holiday, etc. So for those green box, all these items apply. Everything in EA applies to the green box, everything. But those people in the red box, that 6 items that you see at the bottom, the 6 subsections, do not apply to those people in the red box. So I hope now you have a better understanding on what is the first schedule, which provision does not apply to who. Okay. Now I will share these slides in Facebook. So to get the copy of these slides, I will put a copy in Facebook after the webinar today. Now, if you see at the bottom, you can see 2 links. I would encourage you to, click these 2 links, read what is a manual labor. It's important to know how do we classify manual labor, who is a manual labor, what is the percentage of work, that determines whether these people are doing are they a manual labor or they are not a manual labor. So when you get these slides, please read further. Now, so just now I've already mentioned above 4, below 4. Now, how do we determine who is earning above 4 and who's earning below 4? What is the component of wages to determine above 4, below 4? So for that purpose, look on the right-hand side, wages in first schedule. To determine above 4, below 4. So for the purpose of first schedule, wages means you follow what is in section 2. It's a bit confusing for some because, to explain this slide is not easy. But, you may not be able to pick this up today, but get a copy of these slides, read it, digest, go through. I think you'll probably understand. But let me just give you some basic idea. So in order to determine who is above 4, below 4, what is that component? You take the wages definition, but you don't include commission, you don't include allowance, subsistence allowance, you don't include overtime payment. So what I will do, I'll combine, the left box and the right box to give you a easiest way to explain. So when you combine, in order to determine whether they are in the green box or red box, to determine the wages, the wages, you only take the first line, which is basic wages, which meaning basic salary, and all other payments in cash that you pay to an employee for work done. But it does not include all the below items. You don't include the value of house, you don't include traveling allowance, you don't include bonuses, you don't include commission, subsistence allowance, overtime. So now again, we are only determining whether they are earning 4 or above 4, right? We are not calculating OT at this moment. That is a different story altogether. To give you some, a basic idea. So 4 examples here. Example number 1, basic salary 4,000 ringgit. This employee do not get allowances, no commissions, no overtime. So total wages 4,000. He will be entitled to OT because his wages up to 4. Now this is for those who are manual labor. Sorry, those who are not manual labor. Remember this, manual labor, those who are looking after those manual supervisors looking after manual labor, etc. For them, you don't need to calculate. Whether they're earning below 4, above 4, OT is automatic for them. But for those people in the other category, like people like you, right? You need to calculate whether they are above 4 or below 4. Example number 2. Let's say you now have a HR clerk earning 2,005, and this HR clerk also, is also given allowances worth 1,002. So you don't include commission, you don't include OT. Total wages to determine OT, whether they are eligible for OT, is 3,007. Because they are below 4, they are eligible. Example number 3, basic is 3,008, allowances 1,005, commissions, they earn about 200 ringgit. So total is 3,950. It is below 4,000. They are eligible for overtime. Example number 4, basic salary is 3,008, allowances 300, no commissions, no OT. He also does not, not working. He doesn't work OT. Therefore, the total wages is 4,001. Because he's above 4, he is not eligible for, or he's not entitled for overtime payment, because that provision does not apply to him. So this is how you determine whether it is 4 or above 4, right? So just give you an idea, so at least you know how to determine what is the component of 4,000. So let me repeat again. In order to determine what is the component of 4,000, you only take into account basic wages, which is basic salary, and all other payments in cash that you pay to the employee for work done. Got it? Now, if you have any questions, you can put in the chat box. Later part, before I end the webinar today, I'll go through some of these questions and, share my thoughts on this question that you asked. So let me go back to the amendment. Under section, 18A4, what is the formula? How do you calculate wages for a month that is incomplete? For example, the employee did not join on the 1st, they joined on the 10th. Or when they resign, they did not resign on 31st. They resign on the middle of the month, on 15th, for example. Or they took unpaid leave for 1 day or more. The formula that you need to use that is provided for in section 18A, right, is this. Monthly wages divided number of days of the particular wage period times by number of days eligible in the wage period. So if, let's say, you 30 days, you times by 30. Another important provision is section 33A. This is important for companies who are into manpower supply. If you are supplying laborers, you're supplying employees to another company. So what it says here, I'll just read some keywords here. Any contractor for labor. Who's a contractor for labor? If you are involved in supplying manpower to another company, right? You're supplying laborers to another company. It can be engineers as well, or outsourced workers for production. You are called a contractor for labor. So if you are going to supply workers to another employee, before you supply, 14 days before you supply, you will need to register with the Director General, Labor Department, Director General, right? Inform them that you're going to supply manpower. And of course, Labor Director, they can ask for documents and whatnot. So any contractor for, a contractor for labor, if you fail to do so, then it is an offense, and the fine, right? You'll be liable to a fine of not exceeding 50,000 ringgit. That means it can be 50,000 or less. That means not more than 50,000. In the past, it is 10,000, right? So this is not a new provision, but what you can see, the penalty has been increased from 10, maximum 10 to now maximum 50. And of course, there's one item that is added, what you can see in bold. And I think we all know that maternity used to be 60 days, today is 98 days. So why is it 98? Why not 90? Why not 75? Why not 100? The recommendation by ILO is 14 weeks. So 14 times 7 is 98, right? That's why we have 98 days. 14 weeks times 7. Now, let me give you a small tip. When you prepare your employment contract, it is always safer to provide, to mention your notice period in either days or weeks. When we say month, we said, okay, notice period is 1 month. Is it 30 days, 31 days, 28 days, 29 days? What is it? If I tender my resignation on 15th of Feb, what is 1 month? Typically, our instant mindset would say 1 month means 14 Feb, 15 Feb to 14 March. But when you calculate, it is not even 30 days. So what is the definition of month? That is why, to be more specific, to avoid argument, ambiguity, confusion, etc., notice period, whatever that you give, it is always safer. Probation period, for example, notice period, it's always safer to state in either weeks or days. So when you say notice period is 4 weeks, 4 weeks is not 30 days. 4 weeks is 28 days, right? Or if you say 8 weeks, 8 weeks is not 60 days. 8 weeks is 56 days. So it's good to be more specific. Or you just say notice period is 60 days. So no argument. And sometimes people, we ask questions like, if somebody tender on 15 and the notice period is 1 month, is it 14 the following month or 15? That's why when you use number of days, it gives you, or weeks, because week and days is accurate. 1 week is 7 days, or days is accurate. So it gives you a perfect accuracy. So my advice, if you have the chance to review, revise, or if you're starting up a new company, joining a new company, you're going to prepare contract for the first time, you can, please consider using either days or weeks. And new section 41A, it says that, restriction of termination of pregnant employees. So if a pregnant employee, if an employee is pregnant and she is suffering from an illness, that means she's not well because of her pregnancy, you cannot terminate her. Company can only terminate her if there's if this employee has committed a misconduct, or there's a breach of contract, or the company closed the business, right? For this reason, yes, but otherwise you can't. Lately, there's one case that has gone to the, I don't know whether the industrial court or high court. This employee, the whole business, the business unit was closed, not the company, the business unit was closed. And one of the employee in that, among those who, for example, you have got a department and the company says this department is redundant. We don't need this department anymore, right? Maybe they've outsourced whatever. One of the employee in that department is pregnant. So the company terminated. The employee was not happy, went to the court, and what did the court say? Because the court went to this particular provision 41A look at bracket C here, it says that unless closure of employer's business, but in that particular case, the company's business did not cease, only a department. So the court says you cannot use this provision, or it is wrong to use this. So it's good to, that's why I said sometimes read these cases, because it gives us some idea what to look out for if similar scenario happens. If you want to close a particular department and you got one employee who's pregnant, can you say that, okay, business closure? So this case gives us some ideas what the courts will look out for. The other changes, I would say is quite a significant change, is the working hours. In the past, the basic hours is 48, now it is 45. So if you don't know, ILO's recommendation on reduction of basic hours is 40 hours. So, but we stopped at 45. In one fine day, would the government further reduce it? We do not know. But ILO's recommendation is 40. If I'm not mistaken, Vietnam is 40. So now if you see the first item in bold, the minister may make regulations. You know, he can make regulations, he can prescribe, regulations for the purpose of, overtime for employees on piece rate, or he can prescribe matters relating to working at night. So remember the third bubble? So under this provision, the minister, one fine day, he could produce a new regulations, night work regulations 2028. So that regulation is created from this subsection. Got it? And so used to be 48, now it's 45. And if you look at at the bottom, the minister may make regulations relating to allowance during shift work. So that means this provision allows the minister to create another regulation, which is called, for example, shift work allowance regulations 2028, right? So where does it come from? It comes from this particular provision. Okay, so now let me share with you on work hours. When these work hours reduce, or let me ask all of you all this, what are you going to do if the government reduces the work hours to 40 one fine day? Today is 45. What if the government reduces 40? Your OT cost will increase. So what do you do? Right? What do you do? Are you going to complain, whine, why, etc.? The most intelligent way to manage reduction of hours is not about trying funny ways. Like, for example, I heard one company wanted to do this. Ask the employee to scan out, but you still stay back at work, so that the attendance shows that they have already finished clock out, but they're still working. Now, don't do all that kind of trick. Compliance, remember, it's more expensive. If you comply, it's cheaper. If you don't comply, it's more expensive. Now, the best way to manage, reduction of hours, or today you'll be saying that, oh, our OT cost is very high, people are working long hours. What do? The best way, the most intelligent way, the most sustainable way is to focus on performance, discipline, competency, right? Performance, discipline, competency. Now, I want to ask all of you all this. Some of you all could be handling disciplinary cases, right? An employee don't come to work, you got to give them a show cause letter, warning letter, etc. Now, how long this process takes from the time you issue a show cause letter until you give them a warning letter, right? If they don't come to work yesterday, one day, I'm sure you're going to give them a show cause letter, and then you're going to give them some time. They're going to prepare another letter called a warning letter, and you're going to give it to them. So this process, how long does it take? Any comments? How long would you take? Let me see my colleagues here will guide me on the inputs that you give. How long will you take? From the time you issue a show cause letter until you issue a warning letter, the process end to end, how long does it take? Anyone? 1 week, 2 weeks, 3 days, 5 days? $14 days. Now, you take 14 days, I take half an hour. How come you're doing it in 14 days when there are many people out there who's doing it in half an hour? Why do you take 14 days? So you need more time to get your job done, whereas I need limited time or minimum time. So I'm more efficient than you. So now, when we talk about work hours, how do you, so HR need to find ways how to make things fast, how to make things lean, how to make things efficient without compromising governance and compliance. So we got to think of that. So when we talk about reduction hours, don't worry about, oh, now the government has reduced 48 to 45, OT cost has increased, etc. What HR should do, focus on competency, discipline, productivity, efficiency. That's what we are supposed to do, right? I'll share with you more ideas later. And we all know that sick leave and hospitalization leave, they've divorced each other. Previously, the 60 days hospitalization leave includes the 14 days. Now, the 14 days is 14 days, the 60 days is 60 days, so total 74 days, right? So now, again, lots of lots of leaves, right? 74 days used to be 60. So now all this is cost to company. How do you manage it? How do you ensure the abuse is minimal, right? You may be telling me, oh, MC, very difficult. Who says it's difficult to control MC? Who says it's difficult to ensure employees don't abuse? If you don't have proper mechanism, people will abuse. No point we cry, complain, grumble, or my employee MC is so high, etc. Because you don't have proper mechanism to manage it, right? I'll share with you some ideas if you have enough time today, how to manage MC. I would encourage all of y'all, one step you should do is go to the Facebook community, go to Facebook forum, our forum in Facebook. We have shared a sample policy, which is called medical policy. There are some good ideas in that policy, how to prevent abuses. So I would encourage all of y'all, if you're serious about learning how to manage abuses, how to prevent abuses, download that sample policy, read it, see whether those ideas, those mechanisms, those process, those controls that were shared in that policy could be of help to you to reduce abuses. For some employees, these 14 days and all that, these are cuti tahunan tambahan. No enough annual leave, apply sick leave. Who's paying for it? You are paying for it, right? So manage it well. Now, this is just something extra that I thought is important to share. This is not amendment. This has been there for, the longest time. I just would like to bring it up so that we are aware on this. Now, Section 60F of Employment Act, and this is also applicable in Sabah and Sarawak. If you check the ordinance of Sabah and Sarawak, you will see this as well. What it says, an employee, after examination, that means after they've gone for examination, at the expense of the employer, right? Some of y'all, you do not impose panel doctor, they can go to clinic, government clinic, $1. Okay, I'm not talking about those scenarios. If you are going to impose, you tell them that you must go to this doctor, you got to pay that particular bill. So what it says, an employee, after examination, at the expense of the employer, by a registered medical practitioner appointed by you. You appoint the doctor, pay for the expenses. So not consultation. When they go to clinic, there are two components, medication and consultation. So when a doctor provides, charges you 60 ringgit, you're paying for two components, consultation, medication. What is much more expensive is medication. Medication, if the MC cost is 60 ringgit, you're paying the clinic 60 ringgit, the medication cost can be easily 45, 50 ringgit. The cost of consultation, in some cases, 5, 10 ringgit. I lost touch with these rates. The consultation cost is very minimum, but the medication cost for the drugs, right, whether it's a Panadol, a cough mixture, those drugs, those are expensive. So you can choose not to pay for medication. The law says that consultation, or when the doctor examines you, doctor says, oh yeah, you're not feeling well. I think you are having bronchitis, you better take this medicine. That is called examination or consultation. The cost of consultation you got to pay. You don't have to pay for cost of medication, right? So that's what it says here, right? I hope you all aware. So if you're putting a limit, you're forcing an employee to go to a panel clinic, you're putting a limit, you might have committed an offense under Section 60F1. So please go and read this further and see whether you are in compliant or you're not in compliant. Paternity leave. So if maternity is for female, paternity is for male. But just to let all of you all know, maternity leave, local employee, foreign employee. So let's say if you have a foreign operator from another country, female, she becomes pregnant, she delivers a child, she is also entitled to maternity leave, maternity allowance, right? Of course, subject to certain conditions, for example, maximum 5 child, etc. So EA did not say that they must be married and so on. So you cannot put a condition in your policy, a married female employee, because EA, SLO did not say that female employee must be married. So if the female employee is not married, she is also entitled to maternity allowance. A foreign female employee who delivers a child, whether she's an engineer from, let's say, India or Vietnam, or if if that person is an operator, a female operator, whether they are engineer operator, doesn't matter, even a foreigner, they are entitled for it. So same concept to paternity leave. So for paternity leave also applies to foreign employees. So if you have a operator from Bangladesh or a security guard from Nepal and their wives deliver, right? Their wives deliver, they are also eligible for paternity leave. But the difference between maternity and paternity, of course, the duration different. That is 98 days, this is 7 days. But here, they must be married. So for maternity, EA did not say married, but for paternity, you can see the word in green, a married male employee. So if the employee is not married and the wife delivers or his girlfriend delivers a child, he will not get. He's got to be married. And this is for 7 consecutive days, including Saturday, Sunday, and so on, and only for the first 5 confinement. For some of you all may be aware, for the female, they follow first 5 living child. But for the male, first 5 confinement. And he must have worked for you for at least 12 months. So you cannot put in your policy, must be confirmed, because the law did not say confirm. As long as he complete 12 months, he's eligible. Sometimes, probation in some companies, 3 months, 6 months, 9 months, 12 months, it goes on and on because you keep extending. And let's say if your probation goes beyond 12 months, he's still not confirmed yet, but his wife delivers a child under this provision, he is entitled, or this leave applies to him. So remember this, you can't put in your policy, must be confirmed. Okay? And so just a quick test. Remember this, for female employees, only the first 5 living child, the wife is entitled to maternity allowance. But for the husband, the first 5 confinement. So now, a small scenario, right? So tell me yes or no. For the scenario number 1, does the female employee entitled to maternity allowance? And does the husband, the male employee, is he entitled to paternity leave? So yes, yes, no, no, yes, no, no, yes. So give me answer. Yes, the first answer, second answer. Right? My colleagues will share with me what you reply. So in the scenario number 1, the female employee, is she entitled to maternity allowance? Okay? Answer is no. Why? Because that particular child is her child number 6. Maternity allowance is only for the first 5 living child. So the first answer is maternity allowance, answer is no. What about paternity leave? Yes or no? Okay, there's the answer yes. The correct answer is yes, because paternity would follow confinement. So that particular confinement is confinement number 5. So first 5 confinement. I deliberately put this scenario to trick you guys. Like how you sit for SPM, tricky question, this is one tricky question. So remember this, for female employee is the first 5 living child. So when she delivers this particular child, is child number 6. All the other 5 are still alive. So she will not get maternity allowance. Right? Maternity leave, yes, but no allowance. Here, the husband will get paternity leave because that is confinement yang kelima. Okay, that's scenario 1. Huh? What about scenario 2? Would the female employee be eligible for maternity allowance? Yes or no? What's the answer? Okay, anyone? Okay, answer is yes. Why? Because that child number 6 adalah anak yang ke berapa? Yang kelima. Because why? The first child is still alive, second is still alive, third is still alive, the fourth one passed away. The fifth one is still alive. So now the child number 6 is her 5th living child at that moment. So the wife will get maternity allowance. What about the husband? Will he get paternity leave? Yes or no? Anyone? Okay, answer is correct. Answer is yes. Why? Because that is also confinement number 5. So child 1 is confinement 1. Child 2 and 3 is confinement 2. Child 4 is confinement 3. Child 5 is confinement 4. And child number 6 is confinement number 5. So the wife will follow number of living child, husband follow number of confinement. So I purposely made it tricky, just to test you guys. Okay, good. Those of you give good answers, good. Those of you are still wondering how you're still cracking your head, etc., please take some time to read Employment Act on what is confinement, what is the criteria, go and read the maternity provision, you'll get an answer here. And go to the forum as well. There's one, puzzle, I call it trivia. We have given multiple scenarios, whether the employee is eligible or not eligible. Let me continue further. Now, under the new subsection 60K, the old subsection, subsidiary new subsection, I just want to highlight one point here. What it says here, no employer, that means you as an employer, you cannot employ a foreign employee, whether it's a laborer, whether it's an engineer expat, you cannot employ a foreign employee without prior approval from the labor DG. So if you do, then you look at right at the bottom, a fine not exceeding 100,000 ringgit. So the other offenses, maximum fine, not more than 50,000. Here, not more than 100,000. Or the employer can also be subjected to a prison term of not exceeding 5 years. Tidak melebihi 5 tahun. So it can be fined not exceeding 100,000 or not exceeding jail term, imprisonment of not more than 5 years, 5 years, atau kedua-duanya sekali. So it's a very heavy offense to employ a foreign employee without the approval of the Director General. And flexi work. Last week, we had a webinar. Some of you may have joined. I'm just going to repeat what we have shared last week, but I'm going to do it very briefly. Now, under Section 60P, it says that any employee can apply for flexi work. You cannot say no to them because this is provided for in Employment Act. So the employee may apply, right, to vary, mengubah suai, to change place of work, hours of work, days of work. And under Section 60Q, what does it say? When the employee applies for flexi work arrangement, they must apply in writing. And when they apply, you as a company, as an employer, you must reply them within 60 days. Whether it's a yes or if it's a no. If you approve, good news. But if you reject or you refuse, you say cannot, not success, not approve. Section 60Q, also in Sabah Labour Ordinance, Sarawak Labour Ordinance, requires you to give them a reply. You got to tell them why. You got to give a reason why rejected. Okay? If you reject and you don't give a reason why, now you're giving room for the employee to go and, inform our friends in Labour Office that you did not give a reason. So the law says that when an employee applies, you must decide within 60 days, yes or no. If it's a no, you must give them a reason why you rejected their application. So you cannot suka-suka, cannot. Why you rejected? you got to give a reason. If you don't give a reason, you have committed an offense. So please give a reason. A simple table. Now, if you have not done any planning or study of what you can implement, this is a very simple table, a simple guide what you can do. Look at all your positions, what functions you have in your company, operators, technicians, clerical staff, managerial staff, whatever, and you see whether the place of work can be modified. Operator, if the machinery is in the factory, they got to come to factory. They cannot be at home. So place of work will not apply. Even the hours of work, in some cases, you're running, fixed shift. You must come in at 7 because everybody comes in shift, and the morning crew will go, the afternoon shift will come, guys will come in. So you cannot come in bila you want. So hours of work also cannot. But maybe the days of work can. If you don't want to work on Friday, you can, come in on Thursday or whatever the thing is. So different positions may have different outcome. For example, if it's an engineer or an executive or a manager, even a clerk, if they all have laptop, your systems are all, online, can be processed while at home, etc., they can work from home. They can modify their hours. They can come in late. Like, for example, some companies would have flexi hours. You can come in at 9:30, go back at 6:30, and so on, right? So look into this and then decide whether you want to implement flexi work, maybe you want to shorten your shift days, or maybe even part-time work, right? I'll explain a little bit of part-time work. So this is a simple idea how to analyze what kind of flexi work that you could implement. These are some ideas, some tips and so on. I just want to highlight one particular, or maybe 2 or 3 things. Number one, it's always advisable for you to study your operating challenges, constraints, whatever. Look into what kind of flexibility you can provide, set the boundary guideline, tell the employee if you ever want to apply for flexi work, you apply within this parameter. So when you reject, it's easy to give the reason why you rejected. And it is always advisable not to give long-term FWA. Okay, you want to work from home, can, 6 months, boleh. What happens, and this has happened before, the employee apply for a couple of months work from home. After a few days, not replying to email on time, not replying to WhatsApp on time. So, but you gave 6 months. So sometimes it's good to give on a month-to-month. Yes, you want 6 months, we understand, but our policy says you apply every month. First month, finish, you apply. Second month, finish, you apply for third month. So if the first month is employee didn't behave, don't approve second month, right? That's number 2. Number 3, also set in your policy, right? Where is the point of origin? So for example, a sales engineer says that, boss, can I work from home? Or maybe somebody, doesn't matter who, work from home. You say, okay lah, boleh. But his home is in Sabah. So he went back to Sabah and he's working from Sabah because you say, can what, work from home. Now, your client has an emergency and he says, hey, can you send your engineer? Because my machinery is not working. I need you guys to come and, troubleshoot. So you call your employee. He says, boss, I'm in Sabah. You want me to come? I can come. Can you pay my flight ticket? So what is the issue here? We have failed to specify in the policy, if there's a business travel, where is the point of origin? So you got to spell out in your policy, if there's any business travel required, the point of origin is the office. So any travel cost from the office to the client's place is paid by the company. So please set it clear. And also, if the company wants you to come back, recall back. You want to call them back to office for some reason. Maybe there's a crisis, there's an emergency, there's a sudden customer audit. You want them to come back. So you must also put in your policy, the company can revoke, can call you back if you are required. And you must come back the next working day, not after 2 days, next working day. So spell all this out in your policy. So if an employee wants to go on leave, flexi work, he reads all this condition, he agrees to the condition in the form. So please download a copy of the form that you have shared, a very comprehensive form that covers all this, right? If you're already using a particular form, see whether you can improvise it. Okay, so these are some ideas that I've spoken to quite a number of companies, and they kept their FWA policy very simple, very relaxed, and very too loose. When an issue happens, the policy is not going to help you. You call here, call there, how here, not going to work. So draft your policy well. So to help you guys, there is a sample FWA policy. It's a 6-page policy available in the forum. So this is a sample what you can see. You want a copy of this policy, go to the forum, you type the word flexi work arrangement policy, and you will see this policy. It's a very comprehensive one. So this is 6 pages. I do not know how long is yours. If your policy is just half a page, 1 page, I believe it may not be comprehensive enough to cover various situations. So download this policy, see whether there's any good points that you can copy or adapt. Please do so. Now let me move on. So in the past, the other provision is okay. So now, if you have supplied manpower to another company, and your principal, the company that you supply manpower to, so these are for those manpower suppliers, if they fail to pay you for the labor, for the wages that you're paid, and you want them to pay you, right, for you to pay your employees, so any sum which the contractor for labor claims, right, that is due to you, which you need to pay your workers, etc., and they fail to pay, you can drag them to the labor court, and if they are found guilty, they'll be fined not exceeding 50,000 ringgit, and if they they don't comply, right, then there's a daily fine of 1,000 ringgit until they put a stop to it. So this is to also protect those people who are supplying manpower. The other interesting part is discrimination. So if there's a discrimination, the old discrimination provision deleted, a new provision is created. So what it says, discrimination, if the employee feels he or she is being discriminated, they can also file a case at the labor office, and if upon investigation the labor department finds that you are guilty, then you can be fined not exceeding 50,000 ringgit for discrimination. And if you continue to do it, not more than 1,000 per day. So discrimination is a bit difficult, but I give you one example where this could arise. If you give higher increment to an A performer and a lower increment to your C performer or B performer, that is not called discrimination. That is performance-based increment. Or you give higher bonus to the A performer and a lower bonus to a C performer. That is not discrimination. But let's say now you've got two clerks, two HR clerk. Both are same level, same capacity, both are HR clerk. Both got laptop. Both can do work at home. One applied to work at home, you approve. The other one applied to work at home, you rejected. Now, the employee whose leave is rejected may have a case of discrimination. How come the other employee approved, but you rejected mine? I'm just saying may, I'm not saying is, right? Of course, it needs to be investigated, whatnot, etc. So this could be one, element of discrimination. And, this is an easy one, easy to do. Under Section 81 is a new Section 81H. What it says, you must put up, notice in your company to raise awareness on sexual harassment. So you got to put up some notices, either a poster notice, etc., in your company where people can see, not hidden in the storeroom. If you don't do, maximum fine or fine not exceeding 50,000. So I hope all of you have done it. If you have not done so, please come up with some notice, put up in a place where people can see. There are 9 sample posters in the forum. If you do not know how to do one, download it, print it, put it onto your wall where people can see it, or your notice board. So this is easy to do. Otherwise, again, fine not exceeding 50,000 ringgit. Why? Fail to put up notice of awareness. This is easy to do. Section 90B is a new section on forced labor. So what it says, if any employer, you threaten the workers, you deceive them, you force them to do something, a work or service, you don't allow them to leave the place of work, right? You threaten them, you deceive them, you force them. This is considered forced labor. If you are guilty of doing so, maximum fine not exceed, that means a fine not exceeding 100,000, or jail term not exceeding 2 years, or kedua-duanya sekali, or both. So this is another heavy offense. So remember, forced labor and hiring foreign employees without permission, these two, maximum fine 100,000 ringgit, or there's a jail term. The other one is 5 years, this is maximum 2 years, or kedua-duanya sekali. So remember this, do not hire foreign employees without permission. Please do not allow, for forced labor, practices to happen in your or at your workplace. And, this is a very interesting question. You hire an operator or a technician, doesn't matter who. During interview, you ask, boleh tak, can you do OT or not? The employee say, yeah, can. During interview, anything you ask, can you do this, can you do that? Yes, sir, 3 bags full. That's a common answer. Everything boleh. But after they report to work, please do OT. They say, oh, no, cannot, you cannot force me, etc. Now, in the case of Kulit Craft, what the court says, if the employee have accepted the condition that he must do OT, the job requires to do OT, he cannot refuse it later. So remember this, spell it out in your offer letter. But what most offer letters, how companies drafted, if you do OT, okay lah, I don't want to do OT. You say if what? I don't want to do. So that is not the right way to do. A better way is spell it out in your policy, make it more clear. This job requires you to perform OT as per company's work arrangement. Failure to do OT after accepting this offer, it's a breach of contract. Spell it out. Not simple one sentence, if you buat. Kalau you buat OT, you akan dibayar mengikut Akta Pekerjaan 1955. That's wrong. If, okay lah, I don't do. So make your policy, make your provision clear in your offer letter. There's a sample, there's a sample offer letter in the forum, or a sample employment contract. In that contract, this particular clause is available there. So you can go and see how it's drafted. If it makes sense, copy and put it into your contract. So that next time you have no headache, right? During interview, you ask them, can do OT? Can. After joining, they said, oh, OT, you cannot force me, and so on. But of course, companies under RBA, that's a different story altogether. That's another issue to look at. But these are companies, not RBA. Please go in. So I'll share with you as well. So these are 11 indicators defined by ILO. By the way, Labor Department also have produced a guidebook, right? A guideline on the indicators of forced labor. Like what you can see, you can also download this. Labor Department has a copy. I'm not sure, maybe you can get it from Labor Department's website. Otherwise, in our Facebook community, you can also download a copy of the guideline issued by Labor Department. What are the 11 forced labor indicators, right? Of course, we won't have time to go through this, but for those of you, if you're interested to know more, when you get these slides, click on the link, you'll get a copy of this book, or go to the forum, download Labor Department's guideline, or go to Labor Department's website, see whether they can download a guideline on the 11 indicators of forced labor. Read it. And, general penalty, if there's any other offenses, if it's mentioned 10,000 in the past, now it is maximum 50,000. So the penalty has increased fivefold. What used to be maximum 10, today, not exceeding 50,000 ringgit. Who is an employee? Who is an employer? So what section 101C says is this. If you control, because sometimes we are very creative, we give funny contracts, funny labels, don't give letter, all kind of things. So if there's a dispute, am I an employee? Are you the employer? Now, what it says here, if you control their work, you control their movement, they got to apply leave, they got to come in on time, they got to go back on time. If they want to apply leave, they got to apply leave. He's only working for you. And whatever job this person do is a very important part of your business. Maybe you're a programming house, he do programming. That's integral part, a very important part of your business. Only working for you. whatever pay that you give is a major part of your income, then the presumption is you are the employer and he or she is the employee. But let me give you another scenario. A cleaner, let's say, we are in PJ right now. So a cleaner in PJ, Monday, this cleaner, he or she, Monday morning, go to company A, clean the office, 2-3 hours, finish, go to company B, 2-3 hours, finish, go to another company on Tuesday morning, 2-3 hours, finish. So this cleaner goes to multiple companies. Is she only working for you? No. Are you controlling their movement? No. Whatever that you pay them, is that a major part of the income? No. Are they doing something that is important part of your business? If you are a programming house, a software development company, he or she is a cleaner. Answer is no, right? So here, the presumption is you are not an employer, the cleaner is not an employee. So I hope you can see the difference. Okay, yep, you can read this. And I just want to cover a couple of elements. I know some of you all may be very familiar with this, but let me just run through very briefly. What is the formula for HRP? Monthly pay, divide 26 times 8. But now, if your company only works 7.5 hours per day, if you're working 6 days a week, 7.5 hours, then the 8 hours at the bottom, the denominator 8, you got to use 7.5. What if your company works 8.5 hours per day? Again, the maximum 8 hours. If it's 7.5, 7.5. If it's 8 or more, it is divided by 8. And this is just info. There's no changes to this. Just wanted to highlight. You can actually pay for work done on rest day, public holiday, or there's any approved incentive plan. You can actually, you can exclude this from ORP calculation. But sometimes it becomes a bit tricky. Some you include, some don't include. But most of you, I believe you include it. You have made it more favorable. And why is off day? Sometimes we ask this question. Sunday, if you work on a rest day, if your rest day is Sunday, if you work on a rest day, the first 8 hours is 1.0. Why off day 1.5? Why off day is more than rest day? Now the answer is because the design, Employment Act design is 6 days work. So Saturday, for example, if it's Monday to Sunday, 6 days is work day, 1 day is rest. So if Saturday you tell the employee you don't need to come to work, that is called an off day. But you will not find this label in the Employment Act. The label is off day, but it's a normal working day. Therefore, if you work on a Saturday, it is also 1.5. Got it? So some people like to ask this. Why is it off day when you work on a Saturday, if it's Saturday is off day, why the rates are higher than Sunday? Because Saturday is still treated as a working day by Employment Act. There's only one rest day in 7 days. If you got more than one rest day, so the last day is a rest day, the other days are called off days. And wages must be paid by the 7th of the following month. So if it's August, you must pay the salary by 7th of September. But just to let you all know, under Section 92, and this also applies to Sabah and Sarawak, rest day pay, public holiday pay, overtime pay, you can pay, if you don't want to pay by the 7th of September in this case, you can delay until the end of September. So you must pay before the last day of the next wage period. So if the next wage period is 1st October, you must pay before 1st October. That means by 30th September, you must pay rest day pay, public holiday pay, overtime pay. But I'm very sure, probably all of y'all, you're paying all together one go. That's up to you. But there are companies who pays OT before the next wage period. It is still allowed. Why is it? Why do we pay annual leave divide 26? So now, I've got 3 books to be given away. This is a fantastic book, good to great. I would like to give it away to the first answer, why annual leave we divide 26. The first answer, why annual leave divide 26? Anybody can give me this answer? This book is yours. My colleague Yon will courier this to you. Why annual leave divide 26? Anyone? The first answer. Okay, it's a good book, can help you improve your HR practices. Why annual leave divide 26? Anybody? Exactly. So whoever answered 4 rest day, right, Yon, please, contact Yon, give Yon your house address or your office address, we'll courier this book. You are right. Because in a month, we define month as 30 days, there are 4 rest days. You don't apply leave on rest day. You apply annual leave on the 26 days. That's why it's divide 26. Okay, so whoever gave the answer, please reply to Yon. She'll be texting you right now. Give Yon your house address and she will send you the book. Okay, good. So annual leave divide 26. ORP, OT also divide 26. So when we say maximum OT is 104, the 26 normal days times 4 hours OT per day, 26 times 4, 104. Whereas if you're going to calculate incomplete month or unpaid leave, you got to follow the total days in your wage period. If you're following calendar, the total days in your calendar period. Usually it's either 30, 31, unless if it's February. And deductions, right? This is something that I want to highlight. Now, if you look at section 24, also if you look at Sarawak Ordinance, Sabah Ordinance, this is EA, section 24, Sabah, Sarawak, different. The section number is different, but contexts are the same. So you can deduct an employee's salary if you have paid extra for the last 3 months, or if the employee need to give you notice, they don't give you notice, the last pay, you can deduct notice period. Or if you're giving them advance, right, you can collect this advance back subject to certain conditions. Or if there's any other law that requires you to deduct, for example, EPF, SOCSO, income tax, right? So all these are allowed. Now, you cannot deduct for any other reasons unless employee requested, that is in the yellow box, or in another scenario, the employee requested to you, you must get prior permission from the labor director before you can deduct. So there are 3 categories. So sometimes what we do, when we don't pay salary, employee came late to work, we said, oh, deduct salary. Actually, deduction not the right word to use. The better word, the more appropriate word, it is unpaid wages. Because we are paying salary for work done. So if you are supposed to work 8 hours, we pay you 8 hours as per the law. But today you came in late. Instead of 8 hours, you're supposed to come in at 9 o'clock, you're supposed to work until 6 o'clock, minus 1 hour lunch, but you came in at 9:30. Instead of 9 o'clock, you come at 9:30. So the total hours that you work is only 7.5. So what I'm going to do, I will pay you for 7.5. The other half an hour, that is called wages that you did not earn. Some of you will call it deducted. Okay, fine lah. That's just a label issue. But if you want to use the right word, I would say it's either unpaid wages or you want to call it unearned wages. Now, if an employee is late for 5 minutes and you don't want to pay for 5 minutes, it must be proportionate, right? It's got to be proportionate. So if you want to deduct, so-called, you love to use the word deduct, you must calculate exactly what is the value of wages for that 5 minutes. So you cannot have a policy or a rule in the company. You don't come to work for 1 hour, I will cancel half-day pay. Or I will, consider half-day unpaid. You can't do that. It has got to be proportionate to the exact period that the employee were late to work or did not work. So if the employee was late half an hour, you don't pay half an hour. You cannot pay more than that. You cannot deduct, so-called deduct more than half an hour. So, and what happens if an employee, misbehave, was careless, maybe didn't collect money from the customer, and you say what? Since you damaged the company property, or since you didn't collect the sales money from the client, I'm going to deduct your salary. Again, you can't do that. If an employee caused a damage, maybe spoil the laptop, you got to pay 2,000 ringgit to get it repaired, you cannot deduct from the salary because deduction for that is not mentioned here. So you got to claim separately from the employee, not deducting from the salary. Okay, now under Section 2021, again, this also applies to Sabah, Sarawak, but a little bit different for one of this part. So what it says here, I just summarize it in brief. If the contract is terminated today, you got to pay them today, the final salary, right? Except for the third, Section 21 at the bottom. If the employee terminate the contract, without notice, within 3 days or not later than 3 days. But if you terminate them with notice, they terminate with notice, etc., you got to pay them. If the contract ends today, you got to pay them today, not end of the month. So this has been there all the while. I think many of us, we don't follow, right? Casual workers, part-time workers, full-time workers. Now, this provision, this comes from the part-time regulations 2010. It has been there since 2010. So what it says, those employee who works less than 30%, that means if you look at full-time, part-timer, if you work more than 70% of 45 hours, which is if anybody works more than 31.5 hours a week, they are called full-time. Those people who work between 13.5 to 31.5, they are called part-time. Those people who work less than 13.5, you can call them as casual workers. So full-time, part-time, they are covered under Employment Act. So sometimes what we do, the labels we use is not correct. Those people come and help for 1-2 hours a week, we say part-timer. So I would advise you to use the right label. Those people come and help for a while, 1-2 hours a week, etc. Less than 13.5, I would suggest you call them as casual workers. They just come in for casual work, they go. Part-timer are those people who work between 13.5 hours to 31.5 hours. They are part-timers. Provisions of Employment Act applies to them as well. You would fall under full-time employment. So please read it. Now, for those of you, if you're not aware, actually, you can leverage on part-time employment. It's a form of, it's a tool to create flexible workforce. For example, if you have an employee who's retiring, now, I'm just giving you some ideas, maybe you never thought of it. If an employee is going to retire, but actually you don't need, you don't need them full. That means you don't need 100% of them. Some job you can give it to a fresh graduate. Some job only this person can do. You can actually invite them. You cannot force them. Publish your policy on part-time. You can tell them, employees who are reaching, employees who reach 57 years of age, you can apply for part-time job with us. That means instead of coming every day, Mondays to Fridays, 9 to 6, they can come on part-time, maybe every day, half day. Because sometimes these people who are approaching retirement, you don't need 100%. So you realize that they come not much of work because you don't need them full-time. But they come full-time. Because why? Your current policy, your current contract says you must come every day. So this part-time employment can be used for them. Or those people who are not feeling well, those people who, kidney failure, they must go to dialysis 3 days a week. If you have such cases, I'm sure today you will, some days, because every day, 3 days a week, apply half-day pay, no pay, MC, cut here, cut there, etc. Why complicate it? Why not you tell them, hey, we got this part-time job, part-time employment, why not you apply? So they just come every day, Monday, Tuesday, Wednesday, Thursday, Friday, half day every day. Of course, the pay also, you got to proportionally pay them. I cannot be paying you full-time pay for a half-time job, for part-time job. So you got to recalculate the pay, whatever, etc. And you cannot force them, they can apply. So when they apply, give them addendum saying that effective 1st of February 2026, you are on part-time basis, your salary is this much, your work hour this much. If you're going to make some calculation changes to benefits, your benefits are this. He signed, you sign, done deal, right? You don't have to issue another contract. Contract, one employee in your company, per lifetime in your company, one contract. But you can have multiple addendum, multiple additional, letters. You can also give part-time employment for those people. Let's say you have a female employee who delivered a child. She's thinking, should I work? Because, money is not a big deal for me. My husband says stay at home, etc. You can also tell them, why not you apply part-time with us? That means you just come Monday, Tuesday, Wednesday, Thursday, Friday, half day, or maybe you come 3 days a week. The other 2 days, no need to come. We can recalculate your pay. So you can also use this to retain, people, certain skills, etc. And there's many other benefits. So don't be so rigid that everybody must be on part-time. If you have, you can always offer this. I would encourage companies publish this policy so that people can apply. Okay. Now I'm almost at the tail end. I'm going to cover some breakthrough, but before that, we have 2 more webinars this week. This month. Next week, there's a webinar on wages, the definition of wages. And then on 26th of January, we have a webinar on Sarawak and Sabah Labour Ordinance. So please join us, webinar like this, please join us. I'll be sharing some ideas and some details, etc., which might be useful to you. And a small promotion, they say no free lunch. So this webinar, I want to share with you our upcoming class. So now, whatever I've shared today, and all the breakthrough strategies, tips, techniques, how to make your work efficient, case laws, how to terminate employee, if somebody has medical condition, how to manage them, PIP, probation, all the scientific approach to managing probation, how to make your job easy, and all these things we cover in the masterclass. So the next masterclass is going to be in Johor. So if you're listening in from Johor, please consider. It's a 2-day intensive class. Of course, it's not cheap because I'm doing it, and it's very comprehensive. Tons of innovative ideas that I'm going to share. So if you're interested, join us. And of course, if you join us, you'll get a copy of this book if you're in Peninsular Malaysia. For those in Sabah, Sarawak, we'll be giving you a different book that covers Sarawak and Sabah Labour Ordinance, right? So for those of you who are interested, please do join us. Johor, PJ, Kuching, KK, and in Penang. So if you're interested, please email Sophie. Email address is at the bottom. Now, and for those of you all, if you want to equip yourself further, you're a payroll professional, you want to get a paper called Certified Payroll Professional, or you want to learn more on CTNA, how to develop training analysis, or you're a performance management manager, etc. These are various certification programs that we have. If you're interested, do let us know. Of course, it's not cheap because, each program could be 5-6 days. And you can do on a block basis. If there's 3 modules, you can do each module over a period of 1 year. Now, so I'm going to share with you breakthrough. Okay? So listen carefully, because if you can implement this, you will be a very successful HR professional, and so on. Now, sometimes some companies I've seen, they are lost. When I say lost, they just don't know what to do. I got so much issues. I don't know what to do. I don't know where to start. I've tried so many things and it's not working. And then you make yourself busy. The more activities you create, the more busy you become. Okay, we have got employees with mental health issues. Okay, let's do this. Oh, we got employees who say that, when you do an annual survey, people say, oh, we're not happy. Okay, let's do this. We got this problem. Let's do that. Now you start doing this, etc. You will become a zombie. You become so busy that you forget your actual objective. We start to do many things. We only got 8 hours a day, but our JD is 12 hours a day, but we only have 8 hours. So it is very important to know what activities. So this exercise is basically for you to plot what are the HR activities, what are the HR processes that you are doing today, which you spend so much effort, right? If you look at Fool's Paradise, effort is very minimum, the impact also minimum. So this is what I call as Fool's Paradise. Why do you want it? Why do you do it? Right? You're a fool if you do it. Not worth it. You may say, no, impact is, it's okay, like just 1 hour. Why waste 1 hour? Right? So what are the activities you're doing here? These activities, you should immediately stop it. Because why? The impact is so minimal. If it's a governance issue, right? For example, if you issue an employment contract, you got to stamp it. It's a compliance issue. That one you have no choice. But if it's not a compliance issue, there's no issue with governance, please stop it. This activity 1 hour in a month, that activity 1 hour in a month, that one activity, you wasted 3 hours a month. Why waste 3 hours? You could have looked into career progression. Now, the other one is dead man zone. Spend so much effort, so much of time, so much resources, but the impact is minimal. Here, please avoid all these activities. Do you know what activities in dead man zone? In my view, team building falls under this zone. You spend so much of time, so much of money, effort, planning where to go, this, that, etc., but the impact is very minimal. Team building falls under dead man zone. What you should be focused on, find activities, do things that requires minimal effort or not so much effort, but high impact. What are those activities? So this is where you become a champion. Career progression, competency development, competency mapping, doing your TNA, performance management, succession planning. These are here. What most companies, or shall I say, what has happened in some companies, some of you all may agree, the core HR processes, you all cut short, chincai, sometimes don't do. And you start doing things that don't bring you nowhere. So focus on the box that makes you a HR champion. Now, there's another one, which, high effort. You put lots of effort in. And of course, the impact, the results are equally good. Right? High effort, high results. Here, do it selectively. Right? Not everything you need to do. If it's worth it, do it. If it's not worth it, don't do it. Right? So gambler means they decide. Why I say gambler? Because, okay, which card should I throw? Should I put this card or this card? You choose what to do. So you have to identify, if you want to be a successful HR professional, if you want your department to be successful, if you want your company to be successful, from a HR perspective, from people practices perspective, please identify what are the scope, what are the activities that you do that falls into this. Fool's paradise, dead man zone, please avoid it. Unless if it's a governance issue or a compliance matter, do it. Otherwise, don't. Focus on areas that makes you HR champion. So this is one tip for the day. Second is, this is the HR learning and training roadmap. I will share a copy with you. So every level of your journey as HR practitioner, what are the kind of skills that you must have? Of course, this is not a comprehensive list, but it gives you some ideas. What are the competencies you must have? What are the trainings that you must attend? What are the certification programs that you should have? So this gives you some idea. So when you get this slide, please go through it and see what you don't have. How can you upskill? Can you go for a training? Can you do an on-the-job training or whatever? Now, I'm going to give you a couple of breakthrough. So please stay. If you go, you rugi lah. If you stay, you untung, you go, you rugi. Now, I'm already at the tail end. I'll finish these 2 slides, then we'll go for Q&A. But the Q&A is not so important. This is much more important. So let me ask you this. Let's say now, I am going to hire you to produce 3,000 pieces of this every month. Right? 3,000 pieces. If you produce 3,000 pieces, you get a B. You meet. If you do more than 3,000, you get an A. You exceed. If you do less than 3,000, let's say between 2,000 and 3,000, you get a C. Some of you may call it partial or average. But you do way below, you get a D, poor. So now I want to ask you this. What is your minimum? Let's say now if you hire me as an operator or, to assemble this for you, what is the minimum quantity I must do every month? Anyone? What is the minimum quantity that I must do every month? Anyone? 3,000 pieces, right? Now, let me tell you this. Probably all of y'all, you have made this mistake. So, who gives you headache? The A performer, the B performer, the C, or the D performer? Who gives you headache? Anyone? Who gives you a headache? Who gives you headache? I'm resolving a major issue that you all have. Say again? D. Sorry, whoever said D, I don't think you understand the full picture. The C and D gives you headache. Not the D alone. The C and D gives you headache. Now, why the C and D give you headache? Because you allowed the C to remain in your company. You go for team building, you bring everybody, maybe the D performer, you already remove them through PIP. You bring the C go for team building, you spend don't know how much money, go laugh here, there, ha, banana boat, this and that, come back to work Monday, MC first. And then after that, back to square one. Don't work hard, don't want to do more, but you allow them to stay. Because why? Listen carefully, all of y'all. And please tell this to your beloved CEO or your MD. We have accepted C as a minimum. If you do C, no problem. This is where all companies, even some of the big brands out there in Malaysia, big MNC, Hoo-Ha, etc., global company, etc., they have accepted C as a minimum. This is the biggest mistake you guys have done today. You allowed C to stay because you said, okay lah, tak apalah, 2005 pun boleh lah, minimum boleh lah. Why are you allowing yourself to be cheated? As a company, I would challenge all of y'all. Don't have A, B, C, D, E, F. Some of y'all have 6 rating. A, B, C, D, E, F. The more rating you have, the bigger fool you are. Why do I say it? Answer is very simple. You either meet your target, you exceed, or you don't meet. What is this A, B, C, D, E, above, mid, partial, average, below average, poor? What is it? You guys are lost and clueless. You either meet expectation, you exceed, fantastic, good, or you meet. If you don't meet, you are below, you fail to meet. I would even encourage all of you all, 3 level. Exceed, meet, don't meet. If you don't meet, first year, okay lah, no problem, because you're new. Second year, you don't meet. Now, when we say PIP, ladies and gentlemen, PIP means what? Performance Improvement Plan. So the minimum performance is what? Somebody said B. So if you don't get a B, you're below B, don't you think that the C performer needs improvement? From C to go to B? So the C performer needs improvement. First year, you're new, you're learning the job, culture, process, no problem. Second year, if you get a C, you're not meeting my minimum. Go to PIP. But what you guys have done, you have told the C performer for the last many years, no problem. You even give them an increment, small. You give them bonus, small. Medical benefits they enjoy. Annual leave, 25 days they enjoy. Team building they enjoy. Insurance they enjoy. Work from home they enjoy. Then you tell me, oh, I got people cannot perform, cannot work, a lot of headache, disciplinary issues. 70% of your disciplinary issues comes from which group? Give me an answer. 70% of your disciplinary issues, roughly lah. A majority part of disciplinary issues, ladies and gentlemen, comes from which group? Anyone? C and D. So 70% comes from C and D, but you still keep them. You keep the C. And then you grumble, oh my God, a lot of cases, I got this guy, absenteeism, MC here, emergency leave, not coming to work, etc. But you keep them. You give them increment. You give them bonus. I know, small increment, small bonus. You bring them team building. Then you complain. So if you want to change your company's direction, you want to be a high-performing company, you want to grow the company, please remove C and D. First year, C, no problem. You're new. You're learning the process. Okay. Second year, C, PIP. So I challenge all of you all. Your performance management policy or your practices, anybody who gets C 2 years in a row, go to PIP. Cannot, out you go. A and B, you keep them. So this is something that I believe you have never thought of it. You have accepted C. Are you okay? You go to a restaurant or you go to somewhere, they tell you got to pay this amount, you pay 100 ringgit, but the quality of service is not 100. Are you okay? You'll tell me no. So why are you allowing the C performers to cheat you? Why are you allowing it? And then you complain, grumble. 70% of the headache from the C and D. Why company cannot move fast? Why company cannot grow better? Why company cannot increase their revenue? Why company cannot increase their profit? Because you have too many C and Ds in your company. If your company have only A and B, genuine A, genuine B, you will be a very successful company. So now, let me give you a few breakthroughs. There's a lot, but I can only give you a few today. You want to know more? Please come to masterclass. No free lunch, sorry. So let me share with you. Annual leave. If some of you all, you may have annual leave 25 days. The law says 8, 12, 16. But you give 18, 20, 25. Why? Because you want to be employee of choice. So remember this. The C performer that has been around for 8 years also enjoy 25 days. So don't complain if the C give you headache. Because you give them all this. So if I'm a C performer, I will say, you know what? Ayah, tak payah kerja rajin lah. What for? No need. You see, I'm a C performer, right? I also get 25 days, you know. You got A, the guy is A, he got 25 days. I pun dapat juga tau. Team building, I also go, you know. Medical, I also dapat tau. Insurance, I also get. So, you have made C very comfortable to stay. And so in other words, right, you create headache for yourself. So now, I would encourage all of you all, not easy to do, but if you have a chance to do it, everybody, standard annual leave. If you're working more than 5 years, the law says you must give 16, I give you 16. But ladies and gentlemen, starting 2026 or 2027, if you get an A this year, in 2025, if you get an A, in 2026, extra 5 days annual leave. If you're a B, extra 3 days. For next year, for 2028, we will look at your 2027 performance. So A, you enjoy extra 5 days. B, you enjoy 3 days. C and D, sorry lah, minimum. Medical leave. MC. The C and D performers, if I ask you this, who takes the most MC? Anybody answer? Who takes most MC in your company? AB or CD? Anyone? AB or CD? Come on, guys, think. Don't just listen and, I'm not Jim Carrey entertaining you. I'm here to make you think, make you learn. So please participate. Please pay attention. Don't look at your phone. It's okay, 5 o'clock. I know, go home time. Focus, follow. Who takes C and D? So the C and D abuse the medical leave, MC. Despite your control mechanism, more tighter than FBI, Bank Negara, you control, the C and D still abuse it. But all of y'all, I'm very sure all of y'all here, you are the good ones. Bukan hantu-hantu. So the good employees, you probably take 2, 3 days, 4 days, 5 days a year. Am I right? So now, everybody by default, if you do a Venn diagram, the good ones, 3 to 5 days. The hantu-hantu, 10 days, 15 days. So in other words, right, everybody in the company takes 3, 4 days a year. Guaranteed. So now, let me give you a cost-saving strategy and also how to build trust. If you're, ladies and gentlemen, starting 2026 or 2027, if you're an A performer, the first 5 days, tak payah MC. You rest at home, you come back, apply in the system, MC, go rest at home. B performer, 3 days, no need MC. C and D, I'm so sorry, I want MC. Now, what you're doing, you're creating trust. Number 2, do you know how much of money you save paying the clinic? Sometimes people are sick, no need go to clinic. Because why? I just sit down, stay at home, rest. take a Panadol, rest, take some nice hot soup, sleep, rest, tomorrow I'm okay. After all of us are running pharmacy at home, what? Open a cupboard, plenty of medicine. After 2-3 years, throw the medicine away. Then we say we care for environment. So you don't need to go to clinic. You save money. So just imagine, you do your calculation. How many employees are A and B people in your company? If you have this mechanism, this approach, how much of money you save? Tens of thousands of ringgit. Why waste money? Right? C&D, sorry. Ladies and gentlemen, if you are a performer, don't spend money on team building. I'm also a training provider. You come and do team building with us, we make a lot of money. But team building has the minimum effort, a minimum benefits. If team building has changed, some of you all may disagree with me. A training provider, if you're listening today, you're probably angry with me. What is this guy trying to, team building? Now, let me tell you all, you've been doing team building for the last many years. Has team building changed your company? You are a better company compared to last year? You're more progressive, more successful? Your profit has gone high? No, minimum benefits. So instead of spending money on team building, why not you tell your employees this? Ladies and gentlemen, if you're a performer, we will give you 5,000 ringgit from the levy money, HRDF levy, for you as a performer, whatever, like you decide the rate. Go and do a training of your choice. You want to go and upskill yourself, you want to do a professional certification, maybe you're a videographer in the company, a social media guy, you want to go and take up a program on social media, go and do it. Right? If you're a B performer, we allocate 3,000. For example, C&D, sorry, you just, whatever training mandatory you do, otherwise no. No team building. You're wasting money on team building, right? So spend the money to upskill your employees. Ladies and gentlemen, starting companies will import, have a policy on sabbatical leave. If you're an A performer or B performer for at least 3 years out of 5. So let's say for next 5 years, B, AA, 3 Bs minimum. C&D cannot. So in 5 years, no Cs, no Ds. If you can score 3A, 2B in 5 years, that means AAA or whatever, after 5 years, 1 month paid sabbatical leave. Go and enjoy yourself. You want to go China, Hong Kong, you want to go for Umrah, go. Company pay salary. They have earned the money for you. If you're a B performer, 2 days off, paid sabbatical leave. Go and enjoy yourself. So C&D, sorry, you come every day. No sabbatical leave. Now, when you do this, your C&D, there's 2 things that may happen to them, or maybe 3 things. One, they said, this company is stupid lah. This and that, they go. Don't worry about this. This is not discrimination. These are performance-based incentives, performance benefits. Either they go out, or they say, you know what? I still can work hard. I work hard. So the C&D become A and B now. That's a strategy, right? Some of them will remain. If they remain, PIP, get them out. So the faster you get out of C&D, the better it is for you. So now, your company have only employees who are behaving. You see, if I perform well, right, I won't have too many MCs. I will not have too many emergency leave. Today, somebody asked, emergency leave how? If you push for performance and behavior, you will have less emergency issues. But you got to reward them. Either you give them a higher increment, higher bonus, promote them, etc. You got to do something to the high performers, to those who perform. Cannot perform, out they go. I'm sure some companies, if you're a performer, you give higher bonus, good. But C&D, minimum only. So this is a breakthrough strategy. Now, when you do this, right, sometimes in the masterclass, I ask this question: how can you recruit without having to go and find people? How to make people come to you? How to, sometimes not easy to recruit, right? You're not Shell, you're not Exxon, you're not Petronas, Khazanah, you're not all these big brands, right? People go to them, right? Infineon, etc., my ex-company. People come to you. But some of you are just a regular company, not well known. You're not a popular brand. But how to make people come to you? When you have all these people say, hey, you know what? This company here, they got annual leave, they got, sabbatical leave. One of the employees may be on leave. Hey, Adlin, you're on leave today? Yeah, I'm on leave. Where are you going? Oh, I'm going for China for one month. 1 month? Your company give 1 month leave? You unpaid leave? No, paid. You mean a company pay? Yeah. Annual leave, no, annual leave lain. Ini lain. Why, yeah? Oh no, my company, if I perform AAA for 5 years, at least 3 A's, they give 1 month paid leave. Wow, like that. Hey, can I join a company? People will start to warm up to your company. So, what makes me very sad is this. I speak to so many employees, so many HR professionals, either the masterclass, whatever, etc. Most companies menggunakan strategi yang sudah lapuk. What do? Oh, we have got engagement day. Employee engagement campaign is in the dead man zone. Right? Team building, dead man zone. Employee engagement campaign, dead man zone. Mental health awareness day, etc. Dead man zone. You want to know why? Come and see me. Right? If you have been doing engagement campaign for the last many years, your performance tip top? Not really, right? Everybody's happy, working hard, performance, financial good? Not really yet. Dead man zone. So if you can break through this puzzle, you would be very successful HR practitioner. When you go for interview, some of you apply for a job, cannot get a job. You go in, apply, go for interview, cannot get. Why? Because you are just like everybody else. Nothing so fantastic. Why should I pay you 8,000 ringgit? You come, you tell me, I can do this, I can, like a clerk. Anybody can do it. What is so special about you? But when you go for interview and you tell them that, okay, what have you done? You know what? We do the normal things that everybody does, we do. But in addition to that, these are some of the things that I have implemented, right? And this implementation has created higher performance among my employees. What do I do? What do? We crafted a new performance-based reward system. Not just increment and bonus. We do this. Now, the annual leave strategy that I shared with you just now, the medical leave strategy, also saves money. You are able to give more to the A and B without asking the boss money, and you can save money, right? So these are what I call as breakthrough. Let me give you one more breakthrough before I go to Q&A. So those of you all, if you need to go, please go. But if you feel this is good, please stay. Anybody here, you don't give annual leave during probation? I'm going to share with you what is the biggest mistake you guys are making. Do you all give annual leave during probation? Yes, no? Is there anybody who don't give? If you don't give, just say I don't give. Annual leave during probation. Anyone? No annual leave during probation. The law allows it. So do you give anybody here, you don't give annual leave during probation? Okay. Now, those companies who don't give annual leave during probation, I'm so sorry to use this word, you guys are fools. Why do I say you guys are fools? When you don't give annual leave, they will take MC. When they take MC, you're paying for sick leave, you're paying for MC costs. You're paying 2 costs. But when you give annual leave, you only pay for annual leave. After 3 months, first month I take 1 day MC because no annual leave what? For some employees, annual leave, apa itu annual leave? Cuti tahunan tambahan. So first day I take annual MC, second month I take 1 day MC, third month I take 1 day MC. After 3 months, this company useless lah, tak nak lah, I resign. The law says what? You got to pay them whatever leave prorated that you have not given to them. Now you pay another 2-3 days annual leave. So did you save money? No. You actually wasted more money. So the better way is give annual leave from day one. You will tell me, oh, susah lah nak recruit operator. Of course lah, susah nak recruit because you don't give annual leave during probation. So you say difficult recruit and then you don't give annual leave. If I'm an operator, company A, annual leave tak ada. Company B, every day, one month, 1 day. 1 year, 12 days. I rather go there. So if you say you cannot recruit, because you are very narrow-minded, don't give annual leave. So let me tell you this. Companies who don't give annual leave during probation, you are the biggest fool in town. We think that, oh, we won the Great World War. Actually, we are the biggest loser. Why? When they take MC, you're paying for the sick leave day, you're paying for the MC cost. I rather give annual leave. If they resign and go, I don't need to pay them again. But if you don't give, you got to pay for MC, You got to pay for sick leave. After 3 months or 4 months, they go. Whatever days they accumulated, prorated, you still got to pay them. Why waste money, ladies and gentlemen? 3 costs or 1 cost? I rather pay 1 cost instead of paying 3 costs. Okay, so let me go to some Q&A. I will need my colleague here to help me with the Q&A. Okay, so yeah, those of you, if you need to go, I leave it to you. But those who want to stay, please stay. Okay, so yeah, because time is a factor, it is now 5:11. I get excited when I start talking. So let me pick up some important ones. Maybe I won't cover everything. Let me pick up some of the key ones that I think is unique, if it's a unique question, and so on. So Nadira, if employee work for 7 months, don't have annual leave, when the company end employment, should the company pay? Yes. And this is provided for in Employment Act and also Sarawak Sabah Labour Ordinance. Because what the law says, I won't be able to give you exact phrase. An employee is entitled for 8 days annual leave after completing 12 months. So they got to complete 12 months to enjoy the 8 days, right? But the act also says if the contract comes to an end and they've not got this leave, you got to pay them. So Nadira, answer is yes, you got to pay them. Please go and read the provision on annual leave. Sabah, Sarawak, same, huh? Okay. Now, we don't pay for MC claims for probationer. Now, remember this. Okay, you put in Chinese name. I don't know what's your name. Miss Wong or whatever your name is. Now, remember this. When an employee, annual leave you can give after 12 months. But sick leave is from day 1. You cannot delay sick leave. From day 1, they are entitled to sick leave. But annual leave after 12 months. Now, when they go for MC, if you confine them to a clinic, anyway, let's go back to law. Law says that the consultation cost you got to pay. Medication cost you don't have to pay, no problem. Consultation you got to pay. Anyway, consultation, you go to clinic, 10 ringgit, 15 ringgit. The major part is medication. So you can choose not to pay for medication, but you got to pay for consultation, right? So that is the answer for Miss ... because I don't know your name. I can't read Chinese. Okay. So yeah, maybe Jonathan. How would you split the HRDC funds fairly, assuming you have a small pool, you have a small amount of money, but many A performers, right? The A performer takes the benefit and leave. What is your advice? See, for me, it's very simple. My question back to you, Jonathan, and whoever has this similar, question. How can you devise a mechanism where your employees don't want to leave you? You can't just take this one aspect, okay, and ask me, okay, see, nothing wrong with us. I'm just being, constructive and critical. Okay, if they leave. Now, let me ask you this. If your entire mechanism, your mechanics are operating, everything is good, there is no reason for the A performer to leave you. Even if the A performer leave you, so what? Now, remember this, I always tell companies this. Never impose a condition, which affects the majority because of 1 or 2 issues. Because of 1 or 2 bad apples, maybe a small group of bad apples, you create a policy, a rule that also affects the majority of the good ones. I will never want to do that. If for good employees, I will give them special treatment. Those who are not good, either disciplinary issue, performance issue, don't give it to them. Right? So I would say that you got to look at things in a totality. Now, if your money is small, okay lah, maybe this benefit don't give. Or you can say 2,000 ringgit. Or maybe you said, if your performance 2 years in a row is good, we give you 5,000. Or if your company can afford, maybe 2,000 from levy, 2,000 you top up from a company money. Right? Now, this is not a cost, in my view. This is an investment to ensure, to promote, to cultivate, to encourage high performance. Right? But don't look at this as one just one aspect, and we say, what if? Again, I would remember. Let me tell you this. For example, I spoke about MC just now. Because we don't want people to abuse, we say that everybody must give me an MC. If you go an MC, give me. But we all agree, A and B performers, majority, maybe one or two bad apples, but let's put them aside. Majority A and B, they don't abuse MC, except for one or two cases maybe. But majority of them, if they are sick, they are really sick. But the C and D, today leceh lah, public holiday, take MC lah, etc. They abuse. Now, this percentage, no, I don't want to affect the A. I want to take care of the A. So don't implement mechanism or controls. Because of these abusers, it affects the A performance. Think about it. Okay, so next question. Okay, Julia, I have an A employee who can work from home, and the C employee also work from home occasionally. My CEO wants to make a policy to disallow work from home. He doesn't mind A leaves. No one is indispensable. Well, Julia, for me, I don't know whether I want to support your CEO, because this is how, maybe, I don't know, pardon my language, how communism works. Everybody's the same. But if an A performer works hard and he, highly disciplined, if A performer says that, I work from home, I'm quite sure the guy is working from home. Maybe not 8 hours, maybe 5 hours. But if a C performer says I'm working from home, I don't think he's probably working. So for me, and I think any logical and rational thinking CEO would not want to, disappoint, or they don't want to lose an A performer, a genuine A performer. So Julia, my question to you is this. This employee who's an A, is he or she a genuine A? I want to throw you a challenge, Julia. I want you to take one of the best employee you have in your company, the top employee you have, and you ask your boss this. If Sam, who's our top A performer, who has got a skill that nobody else have, boss, are you okay if Sam leaves? I bet you the boss will say, oh, no, I can't. I'm very sure he'll say I can't. But if another employee who's the A, but an A who can easily be replaced, your boss will say, no problem lah. So my question to you is, the A employees that you have, are they genuine A that cannot be replaced? I don't think your boss wants to lose this person. I could be wrong, but that's my perspective. Okay. Now, Vincent, ORP, why divide 26? Or should we do calendar? Now, remember this. When we said overtime, it is only for the 6 days work. That's why it's divide 26, not divide 30. Because Sunday is excluded from the 104. So when we say overtime, right, the normal days when they work extra, that is OT. That is divide 26. Okay? So that's a simple calculation that I can give you. Okay, contract employees, are they entitled to maternity? Yes, because Employment Act, Sabah Labour Ordinance, Sarawak Labour Ordinance do not distinguish contract or permanent. Whether you're contract, whether you're permanent, whether you're local, whether you're foreign, everybody, I mean the female employee lah, all female employees, local, foreign, contract, permanent, fixed term, even their probation for 1 year, they are entitled for maternity. Everybody. Okay, so even contract. Okay, now, Shuhada, ORPAL, we are outsourced payroll, they use 22 working days. Can we divide 22? Now, remember this, EA says this in a layman term. You can use any formula, but whatever formula you use, the outcome or the output cannot be less than the formula provided by EA. So if you want to use 22, it is more favorable. They actually make more money, no problem. But you cannot divide 27. You cannot divide 28. You must divide 26. But Shuhada, please be careful. Once you start doing it, you may not be able to reverse it back to 26. So safer way, if you ask me, I would rather follow 26. But it's up to you. You want to make it more favorable? It's your choice. Okay. Liana, if employee got operation due to accident at work, no medical report received, the employee need to pay. Now, let me tell you this, Liana, you might be breaking the OSHA Act. If an employee met accident at work, you're supposed to report to OSHA, DOSH. So you might, please check, please go and read Akta DOSH. So this is something wrong. So if they meet accident, workplace accident has got to be reported to DOSH, right? Department of Occupational Safety and Health. Now, so are you required to pay? Yes, by default. If the employee is hospitalized, Employment Act says that as long as hospitalized, you got to pay him 60 days of hospitalization leave, you got to pay. So answer is yes, you got to pay. But remember, I think I suggest, Liana, you please read up about DOSH, Akta DOSH. Okay, Akta Keselamatan dan Kesihatan Pekerja. Okay, now, do you think it's good to have 360 performance appraisal for SME Corp in order to avoid pilih kasih? Honestly speaking, this 360, you may disagree with me. I'm a very unconventional person. I don't believe in 360. 360 is a waste of time. Why do you go round the bush to ask about your employee? You go and ask the neighbor, the father, the grandfather, the uncle, etc. Employees, you're reporting to you. So for me, I don't believe in that. Lots of company, you spend a lot of time on 360. Whether you use a tool, you use a paper, etc. So for me, employee, you know him. He reports to you. Why do you want to ask the whole, go around the world to find out about employee? So for me, I don't do 360. I don't believe in 360. In fact, when I was in a particular company, I told the bosses, 360 waste of time. They do every year. They spend so much time 360. But the final rating, the boss still decides. So what's the purpose? Go round. What do you give? A or B? No, I think it's an A. Or I think it's a B. So to me, why spend so much time? Now, personally speaking, you may disagree with me, that's okay. We can agree, disagree. 360, dead man zone. Okay, so maybe one or two, then we call it a day. Any interesting one? Okay, now, this is EA related. Nafiza, maternity allowance. What about maternity allowance for the deceased child? Now, if you go and read the definition, section 2, what is confinement? Sabah, Sarawak, Peninsula, all the same. Confinement means what? If an employee completes 22 weeks of pregnancy, that means the employee is pregnant for 22 weeks. After completing 22 weeks, let's say, we say, what is the word we use? Premature birth, stillbirth, anak mati dalam kandungan after 22 weeks. As long as complete 22 weeks, the wife, either she delivers a child premature or the child died, stillbirth, whatever you call it, she is entitled for maternity leave and maternity allowance. The husband is entitled for paternity leave. So condition, completed 22 weeks. So Nafiza, I would encourage you to go to section 2, read the definition of confinement. It says 22 weeks, complete pregnancy of 22 weeks. Okay, maybe one more question, then we call it a day. Is signing MSS without actual compensation? You see, MSS means mutual, right? So you can do, retrenchment, MSS, VSS, but don't do SSS lah. Suka sek. I got this from Harvinder. So remember this. So MSS, if you don't give a package, then it's not MSS, right? MSS means you mutually discuss. So let's say if I'm working for you, if you want me to go, right? Let's say you don't want me for some reason, shouldn't you offer me something? If you don't offer me, I don't want to go lah. Why should I go? If you want me to go, just like, for example, company closed down, Panasonic, they size down, some company retrench, they offer a package for them to go. So if you don't offer a package, why should I go? Right? So you got to give something. Otherwise, employer said, okay, I tak nak pergi, I will stay. Okay. So maybe one more question. Maybe others. Okay, now this is something interesting. Sarina, maternity leave is 98 days. Can the staff apply only 8 days and the other, 90 days, and the other 8 days, they apply for other leave. Maybe the employer says, okay, I go maternity 90 days, the 8 days, can you convert to annual leave, right? So they come back 90 days, the remaining. Now, by default, if they work 90 days, they want to come back, you're supposed to pay them the allowance of the remaining 8 days, right? Because once they come back to work, they start back salary. The 8 days, you are supposed to pay them. But of course, if company, employee, this is my personal view, you may want to speak to the authorities to see whether this works. If company, employee agree, maybe certain days, maybe that 5-6 days, I convert annual leave, both parties okay. For me, I think it's okay. But please get advice from the authorities. Okay, so thanks a lot. It is now 5:25. Oh, there's a lot of questions, but I won't be able to answer you. But I'm encouraging all of you all, please come and join the masterclass. There's so much of strategies to share, so much of tips. Like what do we cover in masterclass? How do we make our life so much easier? How do we reduce HR workload by 30-40%? How to do things fast? How to remove unnecessary letters? How to remove, how to make your processes fast? How to issue disciplinary, how to manage basic cases in 30 minutes instead of 3 weeks, 1 week, 2 weeks, etc. How to make people come and join your company without you having to do heavy lifting. How to not allow your good employees to leave the company. I've given you some ideas, right? How do you manage out people who cannot perform without having to pay them, right? So these are the kind of things that we discuss in the master class. It's a 2 days intensive class. I'll be doing the class. So if you're interested, write into Sophie. JB class is coming up soon. If you're interested, do join us. And otherwise, thanks a lot for joining us. Please follow us in Facebook. Lots of information, discussion, cases, and so on. So these slides that we shared today, we will be putting up in Facebook. You can download from Facebook community. Thank you so much, and see you the next time I see you. Don't forget to join me in the webinar next week.